Good morning, everyone, and thank you for joining us. Welcome to the BVI Finance Breakfast Forum. I am Elise Donovan for BVI Finance, and I am honored to be your host for today's forum. We're thrilled to have with us what promises to be an insightful and interactive session with Mr. Errol George, the Director of the BVI Financial Investigation Agency, and he is joining us for the first time. Mr. George has been leading the FIA since 2009, and he brings with him a wealth of experience from his extensive background in law enforcement and financial investigations. Today, he will share his invaluable insights into the FIA's ongoing efforts to implement the recommendations for the Caribbean Financial Action Task Force Mutual Evaluation Report. He will also discuss the FIA supervisory process for designated non-financial services businesses and professionals, and the agency's initiatives to enhance collaboration with other law enforcement agencies. In addition, Mr. George will delve into the latest trends and typologies in the realm of virtual assets, particularly with suspicious activity reports. He will also highlight the significance of recent agreements signed with Guernsey, as well as the Bahamas, and their impact on the international cooperation in the fight against financial crime. This forum provides us a unique opportunity to gain a deeper understanding of the critical work being done by the Financial Investigation Agency and its pivotal role in safeguarding the integrity of the BVI financial services industry. First, let me go into the bio of Mr. George. As I say, he's joining us for the first time, so I think we need to do a little introduction. Mr. Errol George is the Director of the Financial Investigation Agency, a position he has held since 2009. And prior to that appointment, he was served as the Senior Investigating Officer at the FIA. He has a background in law enforcement, which includes a distinguished career with the Royal Virgin Islands Police Force, where he served from 1993 to 2019. And much of his policing career, he was dedicated to financial investigations. Following this, he was seconded to the FIA in 2004. As director of the FIA, Mr. George plays a critical role in shaping financial investigation policies and strategies. He's an active member of several anti-money laundering and counter-terrorist financing committees, including the Council of Competent Authorities, the International Committee for AML-CFT Matters, the Committee for Law Enforcement Agencies, and the Asset Seizure and Forfeiture Management Committee. Additionally, he serves on the board of the Virgin Islands Tax Authority. Mr. George holds a Bachelor of Law with honors from the University of East London in the UK and a postgraduate certificate in criminal justice and police management in the University of Leicester, also in the UK. As I said, thank you for joining us for this interactive session. And I am going to we're going to proceed by encouraging all of you to actively participate by placing your questions in the Q&A box. This is an interactive forum, and we would be addressing the questions to Mr. George, and he will, of course, be answering them. I'm going to start off first by asking Mr. George if he can give us an overview of the current status of the FIA's implementation of the CFATF Mutual Evaluation Report recommendations. What are the challenges that you have encountered so far, and how are you addressing those challenges? Thank you.
First of all, good morning, everyone. Thank you, Ms. Donovan, for that warm welcome Of course, it's indeed a privilege and, for me to be here this morning to share some insights into what has been taking place post mutual evaluation process here at the FIA. So, of course, persons on the forum would be aware that, we had a mutual evaluation report. It was published in February of this year. Of course, the report, the details of the report was a bit disappointing, I think, for all agencies that were, subject to the evaluation. But nonetheless, I think it provides a good opportunity to really strengthen the territories framework where AML, CFT, PF, are concerned. So since the publication of the mutual evaluation report, a number of things has been taking place within the agency as we try to implement the recommendations coming out of that report. For those of you who are not aware, I'm sure most of you are, that the agency we're divided into two operational units. We have the supervision and enforcement unit, and we have the analysis and investigations unit. Just to give you a brief background about the role of each unit, I wouldn't go too much into detail because I would discuss as I go along. But the role of the supervision unit is to supervise designated non-financial businesses and professions, and as well as the nonprofit organizations in the territory, the Virgin Islands. And the role of the analysis and investigations unit, which receives and analyze and share information based on the data in those suspicious activity reports. So, like I said, quite a lot has happened since the report was published. Just to give you a rundown of what has taken place within the analysis and investigations unit. Of course, we're working with Claritas. We are also working with Kroll. Both of these entities were engaged by the government to assist the territory to meet the necessary deadlines and to implement the necessary recommendations coming out of the mutual evaluation report. So we engage with both Kroll and Claritas on a regular basis. To date, we've provided our fourth update to Claritas on the work that's been taking place within the agency across both operational units. Now, for example, in our analysis and investigations unit, we were able to go into detail and update our SAR reporting guidelines, which are on our website. We are also in the process of completing a very important strategic analysis project, looking at human smuggling. Ever so often you hear that about the apprehension of some illegal migrants coming into the territory, being dropped off on one of or many islands here in the BVI. So we thought that would be a good project to look at, having seen some connection, some financial flows between the BVI and the US Virgin Islands. So that is a very important project. And of course, one of the things that were recommended in the mutual evaluation report was for us to produce more strategic analysis projects that would basically be of importance not only to the industry but also to policymakers, including government and the government and so forth. So we've been working to complete that strategic analysis project based on information that we would have obtained from the various law enforcement agencies, both locally and and within the region. So we're looking at having that report approved by our board and published very soon, hopefully within the next 2 to 3 weeks at the latest. Of course, one of the things that we're also been focusing on in our supervision and enforcement unit is to actually strengthen our supervisory framework. So one of the first things that we did post the publication of the mutual evaluation report was we updated our risk assessment questionnaire, which basically helps us to determine the level of supervision that's necessary for our designated non-financial businesses and professions sector, which of course includes legal practitioners who engage in relevant business, real estate agents involved in buying and selling real estate property, car dealers, yacht brokers, and jewelers. So we, in updating our risk assessment framework, that enabled us to capture, significant details, in terms of being able to risk rate those entities that would be subject to, to a risk-based approach in our supervisory, in the application of our supervisory process. So that is moving along quite well. When, a matter of fact,
Mr. George,
yes,
I'll just say Errol.
Yes.
Can we go back a little bit and
Yes.
talk about the specific, I guess, deficiencies that were identified in terms of law enforcement and the FIA recommendation that you were particularly addressing? Can you just, for our general benefit, outline what that was or what those were?
Right. So one, for example, as it relates to the agency, I would have spoken about one of the recommendations was for us to produce more strategic analysis products. Another recommendation was for us to produce more money laundering and terrorist financing typology reports, which are equally important. So that is something that we're working on addressing as well. Another deficiency that was actually noted in the report was was surrounding suspicious transaction reporting, where they felt like some of the industry practitioners, for example, were not filing enough reports based on the risk, what they perceive the risk to the jurisdiction, obviously from the point of, the number of companies that we have on our register. So they felt that essentially that there was some underreporting. So they felt like more outreach, was required, more sensitization was required in terms of, helping the financial services sector to be able to better identify, potential money laundering cases during their day-to-day operations. Of course, another one of the recommendations was in relation to, they felt that, we needed to strengthen our domestic cooperation among law enforcement agencies, as well as strengthen our international cooperation, specifically from the point of view of, MOUs, not only MOUs to facilitate exchange of information for law enforcement purposes, but MOUs to facilitate cooperation for supervisory purposes. I did mention, some of the things that the supervision and enforcement unit, some of the work that they're doing. As I said, getting ready to, to conduct on-site inspections and so forth. So, and there were a number of other, recommendations that were made. Some of those recommendations cut across all of the domestic agencies, both the FIA, the FSC, the Police Financial Crime Unit, the Office of the Director of Public Prosecutions. So there were a number of recommendations that were made, and a number of those recommendations were applicable to the FIA. So that's why we've been extremely busy trying to, to meet, the deadlines that were imposed on the jurisdiction. of course, in preparation for its first, substantive report back to the Caribbean Financial Action Task Force and the FATF.
You mentioned that you're going to be essentially increasing your supervisory processes with respect to designated non-financial services businesses and professionals. Can you elaborate on that, and what should they be expecting coming out of the FIA based on the recommendations in terms of your increased supervisory role and how you're going to carry that out?
Yes, so certainly the work that we are doing now is all part of strengthening our supervisory framework. Like I mentioned, a number of designated financial businesses and professions, some of which I'm sure are on this call, they would have received our risk assessment questionnaires. They would have completed those questionnaires, and after completion and submission of the questionnaire to the FIA, many of them would have to date received notices that that they'll be subject to an on-site inspection by our compliance examiners here in the FIA. Now, that process, of course, is quite detailed, where they were asked beforehand to provide, for example, copies of transactions, copies of documentation, including a compliance manual and so forth. So that all feeds in, to the process that's forthcoming, which is actually the on-site, inspections, where they were given a date, when we'll actually come in or go into the various entities, sit with the compliance officers, money laundering reporting officer, other members of the senior management team, to really and truly, assist us, helping us to understand from, the day-to-day, issues around compliance, and just for us, which would allow us to make sure that the various anti-money laundering policies and procedures are actually implemented and are actually working the way they are supposed to be working.
Okay. You also mentioned that one of the things that was seen or identified as deficient is the level of risk, identifying the level of risk and the filing of suspicious activity reports. Can you address that?
Yes, of course. One of the main issues that came out of the report again was looking at risk and risk to the BVI around the companies, legal persons and arrangements. So that is something that certainly warrants attention, and that is something that we've been focusing on. Of course, one of the issues, for example, would have been what, as a jurisdiction, what are we doing, to address the issues of companies being misused for illegal purposes. So from the FIA's perspective, what we have been doing, is actually paying a lot more attention to SARs involving, BVI business companies, because even though the companies are registered here, but they engage in business elsewhere, then obviously, the expectation is that law enforcement agencies in the BVI, including the FIA, as well as the police, would be required to take the necessary action, to prosecute or recommend, prosecution for those companies that are engaged, where it has been found that they were actually engaged in criminal activities taking place. And of course, this feeds into the whole process of international cooperation and working closely with our international partners in this regard.
What are the typologies that you're developing?
Right, we recently concluded a typology report, a TF typology report. It's not published as yet, but we did share it with Claritas. as one of the, the priority things that were necessary coming out of the mutual evaluation report. And that is something, obviously, even though the territory is regarded as the risk level where TF is concerned, is considered low. But again, because of the, international business companies and the international exposure, then clearly this is something that we are expected to, to look at very closely, which we have been doing post the mutual evaluation, or even before that. But of course, now with the mutual evaluation report and highlighting that particular, issues again, linked to the risk exposure to the territory. So we are taking a much closer look, at TF and the risk exposure, caused by, as a result of BVI business companies.
So in terms of terrorist financing, you said the risks are not as high for the BVI, but BVI entities are identified certainly as potentially having to be involved in this risk as far as terrorist financing, and you have developed a typology. Is there anything that you have identified, which I know you haven't, it's not public, but is there anything in there that you can share with us that we should be aware of?
Well, the report itself is not to say that it identify any particular case involving the BVI entity, but it's just, basically a look at how the potential for misuse of BVI entities, because you have, like, for example, BVI entities, they engage in virtual asset, related activities and so forth. And of course, this is something totally separate and apart, but just for us, it was just really to, to be able to produce a report that we felt, okay, was important and it needed to be done as, as a requirement. So we did, but it's just one of many that we hope to, to actually produce, to really, stay on top of things, so to speak.
Okay, so I have other questions, but we've already started getting questions from our attendees. So, Mr. George, you stated in the process of completing the questionnaires and inspections, a lot of documents, compliance manuals, reports, etc., is required. Why then are the firms given so little time, normally 2 weeks, to provide all of the information?
Yes. Essentially, what of course we're coming close to the end of the year, and we set ourselves a target in terms of the number of entities that we'd like, to inspect before the end of the year. And I know, relatively speaking, 2 weeks is a short period of time, but I think we, even though we're open to allow for some additional time, but it's simply because of the short deadline that we have, and the necessity, that we really need to be able to demonstrate again that this is what we're doing, that we're enhancing or supervision. And again, this again is as a result of one of the recommendations that were made in the mutual evaluation report, where they felt that we were not conducting enough on-site inspections of our supervised entities. So yes, 2 weeks is short, but it's because we have, the plan, where we like to complete, a certain number of these inspections before the end of the year.
And we certainly have to demonstrate to the CFATF that we're making sufficient progress. Is that part of it?
Yes, certainly that is part of it, yes.
Okay. With regard to the risk exposures, are car rental companies included in the definition of car dealers?
No. No, rentals are not, even though this is something that we have considered in the past. And we did do a project just, for local law enforcement agencies, focusing on car rentals, because we felt that there is some risk that car rentals can be used, for money laundering purposes. But from an international perspective and the FATF requirements, car rentals they're not subject to supervision for AML.
Okay. For the purpose of DNFBPs, are wire transfers deemed to be cash transactions?
That is something that we've actually discussed internally with the wire transfers, and it's something that we need. I don't think we've actually came to a firm conclusion as to whether or not wire transfers are. But the way we actually look at wire transfers is when we consider wire transfers, and then side by side we consider cash. Wire transfer, clearly there's more of a trail, so to speak, in terms of records and being able to to assess, okay, because wire transfer have to go through the legitimate, financial system. So, we will not look at wire transfer the same way we would actually look at, at cash.
Some DNFBPs are very small businesses and are very concerned about the short time scales and the proportionality. A sole business owner finds it very difficult. It would not be fair that FIA very tight deadlines lead to administrative penalties for otherwise well-run local businesses. What is your response to that?
Well, administrative penalties, that is something that we weigh carefully. I mean, we just don't impose penalties because we have the power to do so. So we look at every situation different. For example, the example that you gave, where you have a single person, owning a small business that because of the type of business that they engage in might be subject to supervision. And that's why I said, we deal with every case, we deal with these matters on a case-by-case basis. So if there's a particular entity and you feel, okay, 2 weeks is perhaps too short of a time, I mean, we can be flexible, to give you some additional time. But of course, what we try to avoid is 2 weeks turning into a month or 6 weeks, because that would sort of derail, our own internal processes and us being able to complete, the on-site inspections within what we consider to be a reasonable time frame, because it is a detailed process. They come in, or examiners go in, they check the various records, as I said, make sure things are actually implemented, and then out of that, you have a report being produced by the examiners highlighting any deficiencies, so it's a very tedious process. So again, that's why we sort of set, timelines in terms of when, persons are expected to respond to a request for documentation and information. But we are flexible in certain circumstances.
Okay, we have another question. What is the FIA doing to stop the use of cash and cash payment in the local economy, knowing that this is a poor use of ongoing money laundering? Or do you agree with that? Because it's not a given that that's the case.
Yes, I mean, we are a cash-based society, even though we have, other options available, but they're still, we're still largely a cash-based economy. And I think the reliance is really on, the regulated businesses, banks, for example, and those businesses who are subject to to regulation by the FSC and supervision by the FIA. It's upon those businesses, if they're engaging in transaction and those transactions are done in cash and they deem those transactions are deemed suspicious for whatever reason, then they're required by law to report, these matters to the FIA by the suspicious transaction report. But in terms of what we're doing, it's very difficult, I think, for us to do anything outside of what we're required to do in terms of, suspicious transaction report or analysis and investigations and working with the police and so forth. But outside of that, it's very difficult, again, because we're still largely a cash-based society.
Many economies, particularly in the developing countries, they have transitioned very readily to electronic payments and other more traceable forms of payments out of being, cash societies. I think the question is alluding to the fact if there's any initiative on behalf of the authorities to progress BVI out of being a cash-based economy into a more, electronic, traceable economy.
Right. Well, from the FIA's perspective, we certainly we haven't engaged in any conversation, say with the FSC and so forth, any other relevant bodies in the agency, in terms of really trying to move things in that direction. Perhaps that is something that are to be done, to be looked at, given the fact that we do, it will sort of make things easier, to legitimize, business, having these other forms of payment besides, being able to use, see persons using a large volume of cash. But to date, no, we haven't had that conversation with FSC, who of course would have to play, a very important role, as well as other key stakeholders, in terms of moving the territory away from being a large, a cash society to a more, more updated, more modern, payment systems and so forth.
Going back to one of the things you said earlier in terms of one of the recommendations is to have more cooperation with your colleagues in the international agencies, and you recently signed MOU with Guernsey, and I think you signed one with the Bahamas as well. Can you tell us about these MOUs and how they help essentially in the fight against international financial crime? And I think you have some more MOUs that you're planning to sign, and what does this mean in terms of meeting that recommendation specifically coming out of the mutual evaluation report?
Yes, so between June and July, we did sign 2 additional MOUs, one with our counterpart in the Bahamas, the Bahamas Financial Intelligence Unit, and more recently, we signed one with the Financial Intelligence Unit of Guernsey. And now, we are a part of the Egmont Group of Financial Intelligence Unit. And within the Egmont Group, it's encouraged to actually strengthen collaboration between, members of the Egmont Group. We had a discussion both with the Bahamas and both with Guernsey, basically to find out whether or not they will be interested in strengthening collaboration between all three, or 3 jurisdictions. So, we started with a draft of that MOU, and after, some deliberations, we decided, well, that we would proceed. So we did, and we signed the MOU. And of course, the benefit of having those agreements is to allow, us to share information, law enforcement information, financial intelligence on a reciprocal basis to aid in the fight against international money laundering and other types of financial crimes, including terrorist financing, proliferation financing, sanctions, related matters. So it's significant. And I think to date, those two particular MOUs, I think, along with what we had before or had previously, we're now at about 16 MOUs we have with other international law enforcement agencies. So they are significant in terms of what the MOUs allow us to do and being able to share information on a reciprocal basis between our jurisdictions. Most recently, within the last 2 weeks, we've also initiated an MOU with the Guernsey Financial Services Commission. And that MOU, we're hoping to be able to sign that MOU within the next 2 weeks. And that MOU in particular is to facilitate cooperation for supervisory purposes, because we felt that it was necessary, to have such an MOU in place. And our intention is to try to get some additional MOUs to strengthen our international cooperation where supervision is concerned. And the reason for doing that is, for example, we have a lot of law firms that are operating across, jurisdictions, in particular law firms that operate both here in the BVI, but have affiliated offices, some affiliations in Guernsey, Jersey, and places like Cayman. So that we feel will assist us to collaborate for supervisory purposes, and just to share a bit more in that regard. For example, we have individuals in the firms that perhaps they move between these jurisdictions. So in being able to properly implement all supervisory processes, if we have what we can actually do if we need information to deem that, for example, a senior officer, a beneficial owner is fit and proper, a new entrant into the market here in the BVI, a new law firm that is operating in Guernsey, now we should operate in the BVI, they, fall to be subject to the agency supervision. Then it allows the Guernsey Financial Services Commission, if that person is coming from Guernsey, if that firm is coming from Guernsey, to be able to share information with the FIA, any important information that we feel is necessary, to allow us to conduct proper supervision of that entity, providing it will be subject to the agency supervision. And it's reciprocal. Again, if they need information from the FIA, we can share that information with whatever information we have as well.
So essentially, we're having more cross-border supervision of all the entities that operate within our International Finance Center.
Yes.
I have another, question. It is encouraging to know that the FIA is seeking to strengthen cooperation with local and international law enforcement agencies in relation to investigations and prosecution against BVI companies involved in illegal activities. Please, could the FIA advise what steps it might be taken where the reverse is true, that is, where a crime has been committed against a BVI company and the BVI company needs the FIA's assistance with investigations being conducted overseas? What specific forms, protocols, procedure manuals are available for the BVI company to reach out to the FIA? Further, what are the steps that the FIA takes to directly liaise with local and international law enforcement agencies? I think you just outlined some of that, but.
Right. So BVI business companies can file and have, filed suspicious transaction reports. I'll give you an example. We've had BVI companies who have been defrauded. They would file suspicious transaction reports. We would conduct, the necessary investigations, analysis on our end. And then we would then collaborate with the local police, the Royal Virgin Islands Police Force Financial Crimes Unit. We would collaborate with any other jurisdiction. For example, if the perpetrator or the suspected perpetrator is in the UK, they're in the US, there are protocols that allows the FIA as the Financial Intelligence Unit to collaborate with any jurisdiction, not only jurisdictions where that, for example, are members where the Financial Intelligence Units are members of the Egmont Group of Financial Intelligence Unit, but any jurisdiction that, that we feel could assist or have pertinent information or useful information to assist in the investigations of criminal activity involving BVI business companies, whether the BVI business company is the suspected perpetrator or the victim of those criminal activities. So there are things in place, there are mechanisms in place that would actually allow us to reach across borders, across jurisdictions, to investigate those particular matters.
I think the question is also asking, how can they access your policies, your procedures, your manuals that allow them to start assisting when they have been the victims of a perpetrated crime?
Right. Well, all manuals are for internal, for our own internal use, so to speak. But feel free. I mean, any instance, anything, if there any occurrence like what you just explained, where a BVI company might be the victim of a crime, they can simply just reach out, file a suspicious activity report. They can, get in contact with the agency, have a conversation, either myself or one of my deputies, depends on which area of which of our operational units needs to be involved, and just have a conversation. But in terms of any policy that's out there that we have published, for example, on our website, there's no policy. All of our internal operational policies are specific for the agency's use. But again, it's not to say that we won't, we're not available to assist in any way we can, when such
what I'm
matters
hearing you
arise.
say is the first order of business is to file a suspicious activity report, and then you
Right.
go from there. What is the responsive time to that?
When you say responsive time in terms of filing a suspicious
if an
activity
agency
report?
files us, they're going through, they feel that they're being a victim of some type of fraud or crime, and they
Right.
file a suspicious activity report. They may be looking for immediate action to be taken. What is your responsive time to that?
Immediate action, of course, we look at suspicious activity reports that when they come in, we actually grade them, accordingly in terms of, the importance. For example, some suspicious activity reports, if they involve, for example, terrorist financing, if they involve child sexual exploitation, if they involve anything to do with sanctions matters, if they involve, of course, the large sums of monies, they tend to be looked at differently, in the sense that, okay, they're seen as priority items or priority matters that need to be looked at, as soon as possible. Of course, we must take into consideration that we do have resource constraints as well, owing to the large number of suspicious activity reports, but they are looked at and they are given priority. But again, it depends on the level of risk assigned, to that report, which would determine what, and the priority that they're actually given.
Okay. Feeling another question, do you support an updated and more practical Proceeds of Crime Act for the BVI and confiscation of assets when you cannot demonstrate how you earned the money or paid for the boats, homes, or other assets you own?
Yes, I do. And a matter of fact, I know there are some proposed amendments that are in the pipelines, are in the works right now, to a whole suite of legislation, including the Proceeds of Criminal Conduct Act. Yes, so I do support that we need to strengthen legislation in that regard, which again is one of the things that were pointed out in our mutual evaluation report. Of course, you would have heard about unexplained wealth. There was a proposed unexplained wealth legislation that's yet to come before the House. But again, that is another important piece of legislation that we feel is necessary and could have some impact. But yes, I do believe that all proceeds of crime legislation needs to be strengthened, and like I said, that is something that's in the works, that currently on the table as we speak.
Where is the unexplained wealth legislation in terms of pipeline? Where is it?
Well, I know it was drafted. But to say exactly what's the current status, I'm not sure. But I know it was drafted, and that is something that was it's been around for at least 2 years. But of course, it's up to the House of Assembly to actually pass the legislation.
We have noted that the FIA has assumed jurisdiction over certain businesses that may not technically seem to fall within the legislation. For example, in the case of a law firm that provides advisory services or does not handle any funds other than the receipt of its own fees, on what basis does the FIA establish a supervisory role over that type of business?
Right. So as I said before, when we send out the updated risk assessment questionnaire, of course, what is provided, or the answers that are provided in that questionnaire, is really and truly what guides our supervisory process in terms of identifying which entities that should be subject to supervision. So of course, but at the end of the day, what really drives, again, the supervision for us in terms of, which of the entities that we'll assess is if that entity is engaged in business that's relevant business according to the FATF standard. So the answers provided by the various businesses in that questionnaire would be the determining factor in terms of whether or not they're subject to supervision. So it's solely based on whatever answer they would have provided. So if they, for example, they say that they engage, they provide, I can see a good example. If they say, for example, that they offer advice to client in relation to real estate transactions of significant sums, then that is something that the FIA would be interested in. So, it all depends on the answer that they provided, and whether or not, again, based on international standard, they should be subject to supervision, because it's deemed by the agency that they actually engage in relevant business.
So are you saying that law firms are simply not in the catch-all for DNFBPs?
No, not all law firms are subject to supervision. It's purely based on whether they engage in relevant business according to the FATF requirements. So not all law firms will be subject to the agency's supervision.
Can you give us any statistics between the number of SARs filed by local businesses and those filed involving BVI BCs?
Before I answer that question, perhaps it's best to explain. So we have, for example, on average, we have what we deem we have two categories of suspicious activity reports. So we have what we deem domestic suspicious activity reports, those reports that are filed, for example, by banks, those reports that are filed by if we have reports that are filed by jewelers, if we have reports that are filed by local car dealers, and then we have what we call international suspicious activity reports. And those are reports that are filed by trust and company service providers primarily, as well as BVI BCs, because like I said, we have BVI BCs that file suspicious activity reports, but in many instances, those BVI BCs that are filing suspicious activity reports, they are linked or connected to virtual assets trading platform. So, so to answer the question, the majority of the reports that are filed by BVI BCs, primarily those engaged in conducting virtual asset related business. So we have I would say about 30% of the reports, maybe even less, filed by local businesses. And then the majority, like I said, of the reports are actually filed by, BVI BCs that engage in virtual asset related business activities connected to virtual asset trading platforms.
Can you talk about that specifically as a trend? I want to come back to the domestic businesses and their transition into being more responsive in terms of reporting suspicious activity. I mean, it's not something that they were used to over the life cycle of their businesses. But specifically, you mentioned that the majority of the SARs are related to virtual asset businesses. Can you talk about that and what trends are you seeing?
Yes. So since about 2018, we noted an increase, a substantial increase in suspicious activity reports relating to virtual assets. Last year, for example, I think we had between 4,000 and 5,000 suspicious activity reports that were filed by virtual asset related businesses operating through BVI BCs, connected that are connected to BVI business companies. And to date, we've had about 2,600 suspicious activity reports primarily related to virtual asset businesses. So that, I think, is a substantive number of reports. And I think if I was to say, what our main challenge is right now, what our main challenge is in terms of that's facing on a day-to-day basis, it would be the large volume of suspicious activity reports linked to virtual assets businesses. In terms of some of the trends that we're actually seeing, we have a number of these reports are linked to child sexual exploitation. We have a lot of the reports that involves what we call dark web related activities, where they engage in illegal persons engage in illegal gambling, person engaged in buying and selling firearms, illegal firearms, and even drugs using the virtual asset trading platforms. Of course, this is something that we're looking at closely. Thankfully, we have a tool that assists us in actually analyzing these virtual asset SARs. Of course, but it's still a problem for us because of the sheer volume. Because as it stands,
Do you have the capacity? I noticed that you're advertising for virtual assets analysts. Do you have the capacity to deal with this expansive volume of suspicious activity reports related to virtual assets? And is it impacting how the authorities are responding to the number of applications we have for virtual assets? I know that's not your domain, but I know there's collaboration among the regulatory authorities. And is it a cause and effect why we are seeing not as fast as a response as we would like to have in the industry with respect to virtual asset businesses because of the risks that you have identified and the number of SARs that you are seeing filed?
Yes, for us, I mean, it's certainly the risk involved in virtual assets business. For us, we have determined that risk to be extremely high. And particularly so because obviously it's taken place in the virtual space. Nowadays, some would say, well, okay, that business is perhaps the best regulated business, even though it's online, it's highly regulated, which yes, it is. But at the same time, based on what we are seeing that there are persons who are actually abusing the space to engage in criminal activity, serious criminal activity. And you ask whether or not we have the resources currently to actually address these issues or be able to deal with these large volume of virtual assets related suspicious transaction reports. The answer is no. We don't have the resources at the moment. But like I said, we did invest significantly into acquiring some tools to assist with the analysis process. At the moment, we have 2 analysts on board that are solely dedicated to analyzing these virtual assets related SARs. But of course, we've gotten to the point where we believe that I think we're at the junction now where we need to incorporate additional technology to allow us to actually cope with the large volume of SARs. And what I mean by this is we're looking at how best we can incorporate artificial intelligence into our analysis product. Just yesterday, a matter of fact, we had a meeting with a company in the UK who specializes in automated systems, including AI, that could assist in helping us to not only risk rate these SARs to determine, which of them actually are to be given priority. But, it will also help us to actually speed up our analysis of these suspicious activity reports. And I think that's the direction that we are going and we intend to go, because we feel in this, I think we might be able to, yes, we might say, well, okay, we need at least 10 analysts, but to be quite honest, there are financial implications, if you're talking about onboarding 10 additional persons just to analyze, these reports. So we feel it's necessary to incorporate, artificial intelligence into our processes, to enable us to assist us to be able to cope with the large volume. So that's the direction that we're actually moving towards at the moment.
So let's move on. We have some more questions. It would be helpful and more efficient if the FIA portal allowed for the upload of supporting documents when SARs are filed via the FIA portal. Are there any plans to allow for this in the future?
Yes. Currently, we are actually looking at the portal because we do realize that there have been some issues with the portal. So we are looking at the portal right now to try to work out some little kinks that currently exist in the portal. But I've made a note of that, and that is certainly something that I'll address with our IT manager, because it's important, to allow, the reporting entities to be able to upload as much documentation as possible, in support of their report. So I've noted that, and we'll discuss it internally with our IT manager to get that problem sorted.
You say you have 2 analysts and you're currently advertising for another. There's a question about whether fintech and crypto, will there be a specialist department at the FIA? I know you said you're going into AI more to help you do analytics. But just to answer this question, is there a specialist department being developed at the FIA to deal with fintech and crypto business?
Right now, we don't have a specialist department per se. The persons who are actually engaged in analyzing these activity reports, these virtual assets related activity reports, they are part of our broader analysis team. But of course, we anticipate that as the number of licenses increase, like meaning the licenses granted by the FSC, to these virtual asset service providers increase, then the likelihood exists that we will have to give some serious consideration to actually having a separate specialist unit to actually analyze these virtual asset SARs, because we do anticipate an increase in the numbers as the number of licenses granted by the FSC increases.
Okay. Small business owners have asked what will happen after on-site inspections. Will the FIA restrict to avoid a perception that some small businesses will be harassed?
No, again, once we go in, or once we come in and we do our assessment, of course, we produce a report highlighting the deficiencies that are noted. Then, of course, the entity that was subject to the on-site examination would be given a time frame by which to correct those deficiencies. And of course, we will work where necessary, walk along with the businesses, including the small businesses who we feel would need perhaps more attention or more guidance, so to speak. We'll walk along with those businesses to ensure that they're able to implement the things that are necessary to be implemented based on the shortcomings that were identified in the report as a result of the on-site examination. Of course, we don't intend to inspect entities every year. We do it based on a risk-based approach that will be taken, of course, and that approach will be guided by our findings coming out of the on-site examinations. So you will find perhaps that some entities may not even be subject to an on-site, maybe perhaps in over 2 years, maybe 3 years, but it depends, of course, on our findings coming out of the actual on-site visit, on-site assessment of these businesses. So it would be purely based on a risk-based approach.
Moving on, is there an MOU agreement between the FIA and the Royal Virgin Islands Police Force for prioritizing the investigation of potential terrorist financing offenses?
Yes. We signed. We had an MOU for a number of years with the police. We recently signed an additional agreement specifically, to address issues like what you mentioned. collaboration, anything around suspicious activity reporting. So that agreement that we signed in June would actually strengthen our collaboration with the police in terms of exchanging information, exchanging intelligence around anything anti-money laundering, counter-terrorist financing related. We had our first strategic meeting last week around this agreement, basically to ensure that it's working in practice the way we envision it in the agreement. So yes, there is something formally in place to allow the FIA and the police financial crime unit to collaborate around these matters.
One of the deficiencies identified in the mutual evaluation report was, I think, the shortfall in the number of prosecutions. And I think leading to prosecutions, you have to have the investigations by the Royal Virgin Islands Police Force as well as the FIA.
Right.
What significant progress, and there's a reason I'm wording it like that, what significant progress are you making to get us to the point where we are having more prosecutions in this area?
Yes, so so in this regard, just to touch on the mutual evaluation report again, so immediate outcome 6, of the recommendations speaks to financial intelligence and how financial intelligence is used. Now, for the FIA, the majority of the financial intelligence coming into the FIA, intelligence produced by the FIA, actually comes from suspicious activity reports. But at the end of the day, if the FIA receive, say, 100 suspicious activity reports, and out of that 100 suspicious activity reports, we, present or send the police financial crime unit 75, intelligence report alleging that, yes, there's money laundering occurring. Unless the financial crimes unit conduct the investigation, then can present evidence to the DPP for consideration, the Office of the Director of Public Prosecution for consideration, you don't have money laundering prosecutions coming out of suspicious activity reports. So how the system really works is that the expectation is that once we conduct our analysis of the suspicious activity report, we share intelligence or information with the police conducts their investigations, or makes a referral to the Office of the Director of Public Prosecution. The expectation is that there will be prosecution, provided that there is sufficient evidence. So because we didn't have any prosecution specifically emanating from suspicious activity reports, we were deemed as having a low level of effectiveness. So, so that goes to show how the system operates, or how it is supposed to be operating according to the FATF standards. So no matter how well the FIA does in terms of analyzing the reports and producing those reports to the police, if we don't, at the end of the day, have a successful prosecution, then the jurisdiction would be deemed as having a low level of effectiveness where money laundering prosecutions are concerned.
Okay, I think in previous years we've been lauding about the IPOC case. Has there been anything akin to that, or is there anything in the on stream that's coming up that's akin to the IPOC case that we can cite again, because that's quite old right now?
Right. In terms of anything that's closely related to the IPOC case, no, there's nothing that's closely related to the IPOC case. But there are some ongoing investigations as we speak. Right now, I know that the police are conducting a number of investigations based on referrals from the FIA. Some of those investigations are linked with sanctions or breach of international sanctions. That could result in seizures, asset seizures. confiscation, but of course they are still in progress. So so we just have to wait and see when the time comes and hope that there will be successes.
Okay. We have another question, so I'm going to follow on that. What is the FIA's annual budget assigned by BVI government? And is it sufficient for your duties both locally as well as internationally?
In terms of our budget, we generally, our budget tends to be in the range of 3 million, somewhere thereabouts. And we know that we are competing for government finances because we're fully funded. We do get some of our funding from FSC, but the majority of our funding comes from the central government. Regardless of whether that is sufficient, of course, it's never enough. Given the number of things that needs to be done, but I think we try to make the most of the finances that we are given, because, like I said, we have to rely primarily on government because we're not a revenue generating, statutory body. But is it enough? No, I think it will never be enough. But at the same time, I believe we are thankful that the funding that we are provided with allows us to move forward with our initiatives.
Okay, I don't see any more questions, so I'm going to ask. You've had a long tenure as in financial investigations at the FIA. How do you see the evolving role of the FIA? I mean, like I said, there's been a transition, particularly for local businesses.
Right.
You've not had to make reports or being supervised, and how have they been cooperating in terms of being supervised by the FIA? How has that transition, the evolving role of the FIA and your expansion into including more agencies and more businesses? How have you seen that over the years?
Well, certainly over the years, the transition, has been significant. When we consider where we were, the FIA, we started as a unit within the police, the Royal Virgin Islands Police Force, and the Financial Investigations Unit before the FIA became a statutory body. And of course, when the agency started or became a statutory body, we didn't envision that it would, transition so quickly to where we are now. Even though we've been in operation since 2004, we didn't, for example, anticipate that we would be given a supervisory mandate, because our focus, the traditional focus of financial intelligence units are on, financial intelligence, producing financial intelligence, for law enforcement purposes to assist in, the fight against financial crime. So when we were told that we would be given a supervisory role, of course, that is something that we weren't quite prepared for. Because you're talking about a different set of expertise, a different set of knowledge that's required, and knowledge that you really and truly only will find within the industry. So here it was, we took on the role of a supervisor, and we were given the task to supervise designated non-financial businesses and professions and non-profit organizations. So it meant that we had to now go out and find the persons, with the relevant compliance experience or industry experience. So that has been quite challenging, for the FIA over the years, simply because, we were still behind as a jurisdiction in terms of the relevant framework, legal framework, to enable the FIA to actually conduct supervision. It's only in 2021, for example, where there was a requirement that where we had the amendment to the FIA Act that required DNFBPs to be registered, for anti-money laundering supervision. And it's still challenging. I mean, even though, yes, we a lot of the businesses are a lot more in terms of the cooperation. They have been cooperating a lot more recently than they have in the past. But I think it's because now they realize, how important it is, for the jurisdiction to actually show that we effective in terms of the anti-money laundering supervision. So yes, it has been quite challenging the transition, from just focusing on financial intelligence to now, more into a supervisor as well. And we're still competing with the industry where, we're identifying the necessary talent and so forth, simply because, of course, we're constrained by or financing in not being able to necessarily, pay what the industry would be able to pay someone with a relevant compliance experience. So that is still a challenge for us. But like I said, businesses generally have been cooperating. I mean, and from time to time they do push back, and we expect that they, that they would push back. But I think as long as we work together, in an effort really and truly for the jurisdiction to show again that we're effective, we can be effective in doing what is necessary, implementing the requirements, coming out of the mutual evaluation report. I think we'll continue to do that and to move forward with our supervision.
How effective have you been in terms of getting the message out to the local community about what is money laundering? And secondly, in terms of them reporting instances of unexplained wealth, for example, or suspicious activity related to all manner of the different types of sub-economies that we are claimed alleged to have in the BVI?
Right. Yeah, of course. We have embarked on some outreach. You recall when we were at the HLSCC, when one of our members of staff presented on suspicious activity reporting. Of course, outreach for us is very important, because we feel that is really the way that we really get persons to be more aware of the reporting requirements, where suspicious transaction reports are concerned, and being able to identify money laundering related activities in their day-to-day during the day-to-day operations. So yes, it is something that we'll continue to do, in terms of engaging with the industry, engaging with those entities that we supervise directly, because we feel it's necessary to do that in order to raise awareness, and the more awareness, the more we can do that, of course, the more compliance in terms of the reporting requirements and so forth, where suspicious activity reports are concerned, then we feel that it would put the FIA in a better position, as well as the businesses in a better position to be able to identify suspicious activities and report those activities once they are identified.
We have a question on, has the FIA and FSC collaborated on any strategic policy plan since the mutual evaluation report?
Yes, we have. One of the things the FIA and the FSC did is we now have a joint supervisory group. So that is something that we felt was necessary coming out of the mutual evaluation, to collaborate as supervisors to basically strengthen, our supervisory processes, not only in the FIA, but the FSC, where we could share experiences, be able to, okay, the FSC would, tell us about how they approach certain things in terms of their, for example, their on-site inspections, and then we would share, how we would approach on-site inspections, to be able to basically feed, off of each other's strengths, which of course in turn would strengthen us not only individually as supervisors, but help us to build that collaborative framework that could assist both agencies, in our individual areas of responsibilities where supervision is concerned.
Okay, we're wrapping up. So if any of our attendees have any more questions, please put them in the Q&A. We do have one question on what can the banks do better locally to stop money laundering in the territory.
Well, I think it's necessary, of course, to continue to train the frontline members of staff, particular, the tellers, for example, to be able to, to report any suspicious activity. For example, if a customer comes in with a large, volume of cash that they want to deposit on their account, just, be able to, to highlight that as something that's yes, that should definitely be brought to the attention of their supervisor or their money laundering reporting officer. Of course, one of the things that is necessary for the banks to do as well is, even after you report a suspicion, based on something that you saw, if it involves a customer, again, use an example of, bringing in a large volume of cash or something to deposit on their account. I think, the banks must, at the end of the day, ask themselves whether or not there's anything else that should be done. Should you, for example, take any steps if you see a repeated pattern where you have the same customer, continuing to deposit a large volume of cash, whether or not, you continue having that particular customer, that particular individual as a customer. Of course, it's totally up to the banks to decide, or any institution to decide, based on your risk appetite, whether or not, you'll continue to have that individual as a customer. But it is something that we think is necessary to highlight, that for sometimes, bank, they might file the reports, but the question is asked, okay, if you file these reports, you probably ended up filing multiple reports on the same customer. Should you then take steps to actually, cease doing business with that customer, having that person as a client or a customer? So that is something perhaps the bank should consider as well, in terms of, when they see suspicious activity reports, and suspicious activity being perpetrated by customers.
What can you do with the banks that essentially are very risk averse, and there are many reports on the banks, taking proactive measures and shutting accounts? I think sometimes even without suspicious activity reports. So they're being preemptive and throwing the baby out with the bathwater. What are you doing to address that?
Well, again, sometimes from time to time, we've had discussion with banks. We've had meeting one-on-one with banking institutions in the BVI, around suspicious transaction reporting, and sometimes lack of suspicious transaction reporting. So we've collaborated on a number of occasions, perhaps not with all of the banks, but that is something that we know is necessary. Hence the reason why we're actually just now finalizing on the outreach programs, both in our supervisory unit as well as our analysis and investigations unit. But particularly, as we are talking about banks, where our intention is to actually do a lot more outreach, with the regulated institutions around suspicious activity reporting. Again, helping them to not only be able to identify suspicious activity reports, but just to strengthen our collaboration, with the banking institutions and the other regulated institutions around suspicious activity reporting. So that is something that we intend to do a lot more in the future, having that engagement, that type of engagement with banks and other reporting institutions.
Okay, we have a final question from our attendees. Can you confirm what is a threshold for transaction based on the business invoice amount or underlying transaction? We quoted $15,000. But can you confirm what is the transaction threshold?
Well, the threshold amount that we use for supervisory process is $15,000. That's the threshold amount that we use for all supervisory processes here at the FIA around all supervised entities.
Is it based on the business invoice or the underlying transaction? I think is the question.
If it's based on the business invoice, it would have to be the transaction.
Okay.
Any transaction 15,000 and above. So it's based on the transaction, the individual transactions.
Okay. Well, Mr. George, it's been quite an interesting conversation. We've had quite a number of questions from our attendees. Before I wrap up, I'm going to give you an opportunity to essentially give us, your outlook for the Financial Investigation Agency. As I said, you talked about your evolving and changing role and how you've transitioned from just being an investigative agency to a supervisory agency. You've talked about the number of suspicious activity reports. You've talked about virtual asset business and the types of typologies that you're seeing. We've talked about the risk and how you identify those risks and the MOUs that you're signing with different jurisdictions to assist in the fight against financial crime globally. So what is your outlook for the Financial Investigation Agency in terms of the evolving global challenges, and how do you want to wrap up this conversation?
Yes. In terms of my outlook, my outlook is very optimistic. I have an optimistic outlook in terms of the direction that we're now heading. Not to say that the process to actually address the deficiencies coming out of the mutual evaluation report has not been a drain on our resources, because we have our day-to-day work, as well as these additional things that that are necessary to be done to address the mutual evaluation report deficiencies. But like I said, I have a very optimistic outlook, because I think the mutual evaluation report and the recommendations that came out of the mutual evaluation report, I think, provides a good opportunity for the FIA, to implement, the shortcomings that were identified, and I think we're well on the way to doing that. I know, I have a very dedicated team here, across the agency who, they're working extremely hard on a day-to-day basis to actually meet the necessary deadlines. And I do believe that at the end of this process, I believe you'll have a better functioning FIA, one that's more efficient, but first and foremost, one that is more effective in terms of trying to work with our domestic partners or international partners to keep the financial services sector in the BVI safe, protected. So my outlook is very positive, and I do I like to actually commend you for the work that you're doing in the International Finance Center, because I know you've been quite helpful to the agency especially with your weekly newsletters, allowing us to actually piggyback off of that weekly newsletters and provide little snippets of what we do. And that is something that we intend to do. And I think this was a good opportunity for me to be able to, to come on and share some of what's been taking place behind the scenes within the FIA to address, the deficiencies noted in the visual evaluation report. So it was a pleasure actually being here and having this conversation with you and persons that are actually logged into the forum.
So you'll let us know when session 2 will take place. Thank you so much, Mr. George. We've been talking with Mr. Errol George, the Director of the Financial Investigation Agencies, on updates to the recommendations for the mutual evaluation report and essentially what's going on with the Financial Investigation Agency. We are so pleased that so many of you were able to join us this morning for this discussion. And I know Mr. George is going to be back. This has been his first time on a BVI Finance Breakfast Forum, but it certainly will not be his last. And again, we want to thank you for participating and sending your questions. We again will be making this video available on our website as well as our YouTube page. We will be sending out a press release shortly, I think in our Friday newsletter as respect to this forum. We want to thank you again for joining us for another BVI Finance Breakfast Forum. I am Elise Donovan for BVI Finance. Do have a pleasant day.